All right, well, let's do this. Good morning, everybody, and thank you for joining us for today's webinar on Senate Bill 1159 and Assembly Bill 685. And so this webinar today is going to focus on the guidance on complying with these two new COVID requirements, reporting requirements in this new world we are living in. All right, Sinead, let's forward through and talk about who we all are this morning. So I am Joe DeLucchi. I am the president of Cal Insurance. What we do is we design insurance programs for businesses, for schools, for nonprofits, for real estate investment groups, and for successful families across the United States. I'm joined today by a powerhouse team at ESM, our great strategic partners. That's Anthony Poston that you see up there on the upper right-hand corner. He is the CEO of ESM Insight, and his background is on the risk management side. Then we have Abe Jaban, and he is with ESM as well. And he supports some of Cal's clients with their workers' compensation claims management in very strategic partnership with Abe and his crew that support our clients in that manner, because that has how those claims are handled has an impact on the experience modification factors. And Abe has a background actually formerly as a workers' comp claims adjuster. So he's been on both sides of the aisle. And then we have the great Sinead Scrosopi. So she is someone that Cal clients will speak with. She is the customer success czar over at ESM Insight and also running the slides today. So thank you, Sinead. Let's move forward. So this is our 7th time together, and I think there's a number of folks, a number of attendees who have been with us since the beginning. So, you know, in March, we were trying to figure this all out with the exposure control plan, then the remote work program, managing claims. We learned so much, and so much had changed in May, in June, in July. And now we're at these new regulations that have come to play, and we want to make sure that you are in compliance and that OSHA is not tagging you for non-compliant fine here. So we've had 7. This is going to be the 7th in our series. Sinead, let's continue. And so our topics today, we're going to get an update, you know, where we've been, where we're going. We've got a couple of real live case studies of Cal clients, actually. And we're going to go over both of the particular bills here, an employer case study. So let's move forward. Sinead.
All right. Thank you, Joe. I love it. Customer success czar. I think I'm going to change my signature today. I love that. So I just wanted to go over some presentation housekeeping today. Everyone is muted, but if you do have any questions, we will be monitoring our question and chat box. So if you have any questions, definitely type them in there. We'll be monitoring those throughout the presentation. We'll try to get to all of your questions, but if not, we'll definitely be reaching out afterwards with some answers for you. Today's presentation is workers' comp focused. We will be also focusing on safety and Cal-OSHA compliance. Everything that we share here is a framework for your COVID risk management at your organization. We have some great resources that I will be putting throughout the chat as well, so check out for those. You'll be able to get them real time, and I will be sharing those links with you. Q&A, obviously it's not necessarily going to follow. We're going to try to answer your questions throughout, but definitely if you have any questions, last time we did this, we left the chat open just for a few moments after the webinar is done. So definitely check out for that. If you have any questions that you think of at the very end, just type them in there and we'll get back to you as soon as we can.
And Sinead, I know people might want to watch this recording or share this recording with their colleagues and others. So we expect this to be available. I know we have this question at every webinar. When is the recording going to become available? Typically, Cal distributes it about a business day or two after the conclusion of this webinar.
Yep, absolutely. So these resources will be available for you. All the links that we are sharing, we'll share them again, as well as a PDF of this presentation. And like Joe said, a recording. So with that, we're going to just kick it off. So Anthony is next with a COVID update.
Good morning, everybody. Thanks for being here. And Joe, thank you and Cal team for co-hosting with us again. We really appreciate the valued partnership. And so we've got a lot of content in this webinar again today. We jam pack it. So we're going to probably run up right against time. So we'll try to monitor that chat and question box so we can answer questions kind of intertwined into the presentation. But again, we'll create some FAQs afterwards to get those to you because these two bills in particular are going to continue to unravel in the coming months. So Sinead, let's do a little California update. So for those of you who are not familiar with the tiered system or haven't been on a prior webinar of ours, California rolled out this new tiered system about a month ago, a little over a month ago. And what I really like about it is they put a framework together that didn't exist before, where each county had to have their own specific mitigation practices. And instead, the state put together this tiered system. And we've got these 4 tiers, which you can see here: widespread, substantial, moderate, and minimal. Now, in order to move from one tier to the next, a county must spend at least 21 days with a reduction in case rates and test positivity. And so once that occurs, it can move to the next tier, and the business or those operations within that county can open up a little bit more. So you'll probably see as you go out to grocery stores or restaurants or coffee shops, you start to see that these organizations are starting to open up a little bit more, which is excellent. And we'll show you some specific stats and how we're seeing that reduction in case rates and test positivity. Now, the one thing that is built into this tiered system is an emergency brake. And so we have seen this in a few counties where that emergency brake has been pulled because the county moved from minimal to moderate or moderate to substantial. And that is going to mean they're going to close those operations a little bit more. So rather than 50% capacity, it could be 25% capacity. And so Sinead, let's go to the next slide. So here we can see in California, just in the last month. So this started in September 1st, roughly, and you can see I've taken snapshots every 2 weeks. Now this data is updated every week, Tuesday, and we're going to show you the link here in just a second. But you can see just the positivity rate continuing to decrease. And if you look at the color scheme of California from left to right, you can see that there are a lot of counties that are moving from widespread to substantial to moderate to minimal, which is excellent news. So we're starting to see a reduction in test positivity. Again, excellent news, but by no means can we become cavalier about this. And we're going to show you a case study where an organization had almost 90% of their staff quarantined because of potential exposure. So as employers, as decision makers, we need to make sure that our COVID compliance mitigation plan is continued to be implemented. And we're going to show you some tools that you can use to document some of that process here in an upcoming slide. This next slide just shows the business activity and business tiers. So just a real quick recap, you can see as you move from one tier to the next, left to right, you can see the capacity in which an organization within that county can start to open. Sinead is going to post this link here in the website, in the chat box. I encourage you to look at it, find your specific sector, your industry, and then continue to work towards helping your county, your community move from one tier to the next. Our goal is getting down to the minimal category, and we're already seeing several counties into that sector that we hadn't seen before. So Sinead, let's go one more here. And this is just an example. As you can see, all of the counties that are in green, these are counties that have moved from one category to the next, from one tier to the next. And you can see most of them have moved down, except for the 2 in yellow that have moved up. So when this program first was rolled out, we had 39 counties in California categorized under the widespread tier. And now you can see there's only 16. And so we're continuing to see counties move in the appropriate direction. And that is a testament to everybody's efforts in mitigation and implementing these COVID-19 reduction strategies. So keep your foot on the gas, be very cognizant of your organization's COVID-19 exposure control plan, continue to implement that every day. We're going to talk about how one organization was able to defend themselves against an OSHA allegation here. So Sinead, let's go to the next one here. So along that thread, this, if you recall from last month's webinar, we talked about an employer who had a disgruntled employee, and they complained to OSHA about these 5 alleged conditions. First one, Title 8 CCR 3203, that's the Injury and Illness Prevention Program communication element. And you can see employer does not communicate training and safety meetings to employees in a language they understand, which was Spanish in this case. And as we work our way down, employers not following their internal COVID-19 policies. It's a pretty broad allegation. Employer does not enforce a 6-foot physical distancing policy. They haven't installed partitions. They haven't implemented a portable high efficiency air cleaner or modification to increase outside airflow. So,
And Anthony, I just want to say real quick
sure.
here, I mean, as we're going to come to determine, each one of these allegations was false. And that's the issue here, is it just takes one disgruntled employee who gives an anonymous tip to Cal-OSHA. Now all of a sudden the employer has an issue where they need to prove that they are in the right. And luckily it worked out here, but I just wanted to hammer home that particular point.
Yeah, absolutely. In California, you're guilty and you have to prove your innocence. And even more so with these two bills, which Abe is going to dive into in just a second. But you can see here, Title 8 CCR 3203 A4A6, this is the Injury and Illness Prevention Program. So Cal-OSHA is leaning on the IIPP for an employer to identify workplace hazards and correct workplace hazards. So that's a really broad way of saying, hey, you haven't implemented your COVID-19 mitigation practices. You haven't installed partitions at assembly tables. You haven't implemented an HVAC system. So nowhere in the standards does it say you have to do that. Now they're just leaning on the IIPP to enforce this. So Sinead, let's go to the next slide, because this is kind of closing the storyline from last month's review. So real quick recap on the top. As we discussed last month, what we see mostly when Cal-OSHA sends an employer a letter regarding alleged conditions, they'll typically have 15 to 30 days to respond. In this case, they have 5 days. And so 5 days happens really fast when you have to go through each one of those alleged conditions and develop or gather the documentation to really discredit that. And so we work with the employer, me and Joe in particular. We put together our draft letter, and we've used this letter in response to certain allegations like this before in the past, and it's been successful. The employer gathered all the documentation, discredited every one of those conditions. We submitted it to Cal-OSHA within the 5-day requirement, and the result was Cal-OSHA closed the case within 3 weeks. And I can tell you, I'm working on a lot of cases where that's not the case, where the OSHA officer ended up coming out after we responded, and now it's been an ongoing inspection and investigation for 4, 6, 8 months. So this organization really dodged that bullet, but they did so because they had a good program in place and they had
were well
all the
prepared.
documentation.
Well
Yeah,
prepared.
absolutely. Yeah, and you can see just the additional benefits of that. So close the case, no further inspection, which just opened up more standards to comply with and potential penalties. And we'll show you a slide here of some of the citation amounts we're seeing, which are $5 to $50 to $200,000. And these are civil penalties. They're not covered under insurance. And most importantly, there's no public record of this inspection. So it's closed. When the underwriter is renewing or evaluating your policy for renewal, they look at open OSHA investigations because they want to know, why is OSHA investigating this employer? Is there something I don't know about? Is there a serious injury or illness that we're not aware of? And so this is one of the criteria underwriters can use to evaluate your renewal.
And in this particular case, our client was going through the renewal at this exact time. And so that that made it even more imperative that this get resolved immediately, which it was, thankfully.
Yeah, that was a big win. We celebrated this. I mean, it's one more big initiative that the safety manager and team would have had to tackle, which is just satisfying the OSHA inspectors' requirements. And Sinead, let's move us to the next slide. So here's one thing that I just saw yesterday, that OSHA currently has 60 open associate or assistant safety engineer job recs open in California right now. So they are hiring safety engineers. Now, these are junior safety engineers, but they have a badge and they have the ability to enforce employers to bend at their will. And Abe's going to talk about 685 and how that's really increased Cal-OSHA's authority. And here's just some examples. And Joe had sent over a few of these as well, and we curated just a few examples of some of the penalties and citations that we're seeing. So on one end, we're seeing a reduction in test positivity cases, which is excellent. Two, what we're also not showing here is all of the OSHA inspections at an employer site where they have passed the COVID-19 mitigation test. So we're seeing both good things happening within the state and that reduction trend. We're also seeing good things happen at employers when OSHA does come and investigate, but then we're also seeing the flip side, whereas an employer has to scramble to get all of that documentation to discredit each one of those allegations, and then also having to deal with penalties and citations. So it's really all over the map. So the best thing that you can do is continue to come to our webinars, listen to some of the content, take some of the tools, make sure that you're implementing those so that you can continue to build your affirmative defense should you be subject to one of these potential allegations. So I was reading up on Oregon OSHA in my spare time because that's what I love to do. Not really, but what we do know is Washington, Oregon, and California have somewhat banded together to create these COVID-19 standards. Now, nothing has really been passed yet. Virginia is the only state that has actually passed a COVID-19 standard. But here are 9 elements within the Oregon OSHA bill that we assume will pass, and then that will trickle down to California and trickle up to Washington. So I just want to review these real quick because there's 2 in here that are different from what Cal-OSHA's reopening requirements are under COVID-19. So first is prepare a risk assessment that involves employee participation. So have you involved your employees? Have they participated in helping to develop your mitigation practices? Number 2, ensure face coverings are required. Number 3, appoint a distancing officer. That's a new one to ensure the 6-foot distancing rule is enforced. Number 4, conduct training and post information in the workplace. If you've been on our prior webinars, we've curated a ton of CDC posters. We've developed other COVID-19 trainings that you can post and use for trainings to your staff. 5, clean common areas and equipment. And number 6, comply with ventilation requirements. So number 3 and number 6 are new. And that goes back to that alleged letter that we just saw where we had those 2 conditions, physical distancing requirements and also ventilation requirements. Number 7, reassign employees when a public health agency or a medical provider recommends they quarantine or isolate. 8, advise other employees when an employee tests positive for COVID-19, which falls under 685. We're going to talk about that in just a second. And then number 9, the general broad brush of the stroke, comply with industry activity guidance. So if you recall, Fed OSHA had a 7-point opening requirement, a reopening requirement. And number 6 was follow OSHA standards. So as you know, the OSHA standard playbook is enormous. And so when we see these disgruntled employee complaints, what that does is just open up the door for OSHA to come in, potentially, unless we can discredit those allegations like we did in that last example. But when they come in, they're not just looking at COVID-19 mitigation practices, they're looking at other standards as well. Machine guarding, housekeeping, lockout, tagout, fall protection, depends on your industry. So again, this is a good time to just get a gut check on your overall safety program. You have the employees' attention and awareness of safety. So revisit some of those additional safety policies and training and start to put together your game plan for 2021. And that's going to be actually one of our next webinars in November and December. So stay tuned for that. All right, let's take a poll, Sinead. So now that we just saw those 9 elements that could potentially fall under a new OSHA standard, let's put this to the test. So number 1, I want you to select all that apply. So have you prepared a risk assessment that involves employee participation? Number 2, ensure that face covering requirements are met. Appoint a distancing officer to ensure the 6-foot distancing rule. Remember, that's a new one. Conduct specified COVID training and post that information. Clean common areas and equipment frequently. Comply with ventilation requirements, another new one. Reassign employees and quarantine them or isolate them if determined by a medical provider. Next one, advise other employees when an employee is tested positive for COVID-19. We're going to talk about that under 685. And then comply with industry guidance. And then you have training documentation for all of the above. I'll give you just a few seconds here. Okay, let's see.
That also triggered a few questions too.
Yeah, let me look over here.
Give them like a few seconds. They started a little late. We have some shy participants. Oh, let's see.
You can only select one box is what I'm seeing from a couple of people right now.
Oh, I must have set this up wrong. Apologies.
And panelists, we can't vote. Zoom.
So let's I think move forward because the select all isn't working.
Okay, so what I do know, and having done this before, is that what we're seeing a lot of are most of these are, I would say employers are about 75–80% compliant with all of them but the distancing officer and the ventilation requirements. And somebody had posted, what are the ventilation requirements? It's a good question. It's a really generalization of what do we do? So the example that we gave before, OSHA said, well, open the windows and open the doors to increase air circulation. And this organization cannot do it because it poses a security risk based on what they do and where they're located. So we can't just open the doors. So then the recommendation was to increase air filtration, and they already have a good HVAC system, part of their GMP requirements. They don't want to cross-contaminate some of the product. So we had already implemented some of these procedures. And so it was really just more of defending against this alleged condition. So again, you're guilty and then have to prove you're innocent. So Sinead, let's go to the next one here. So for those of you who might have said, or let's just make an assumption, we don't have a lot of signatures on training documents that verify that we have trained the employees on all of our mitigation practices. So we put together this one-page employee acknowledgement form, and it's in English and Spanish. And you can see here just at the top, we've got acknowledgement, we've got responsibilities, and then if I test positive for COVID-19, there's some additional steps that they need to take. On each one of those lines, you can initial, the employee can initial that they understand and they've been trained, and then they'll sign at the bottom. So again, English and Spanish. Sinead's going to put this form in the chat, and this is something that you can use for our Insight customers. It's an editable format. It's a Word document, so feel free to log into the portal and download that. And then for everybody else, it's a PDF right now, but you can copy and paste and modify it to fit your organization as well. But again, going back to discrediting all those alleged conditions, here's one document. And had that employee who alleged those conditions to OSHA sign this, then we would immediately have some affirmative defense against every one of those allegations.
And thank you, Sinead, for posting the link for that, to grab that particular form.
All right, let's talk about recording. So when do I record a COVID claim on my OSHA 300 log? So two things have to happen. One, it has to be work related. And how do you know it's work related? Well, the carrier has accepted the claim. So we're using that as the threshold. If the claim, if the COVID case becomes accepted by the carrier, then we report it on our OSHA 300 log. Otherwise, if the carrier is denying it and saying it's not work related, then technically it's not work related. And so we would not post it on our 300 log. So that's just one of your triggers. If it is work related, we know we have to document it on our OSHA 300 log. Sinead, let's go to the next one on reporting. Now under reporting, so this has changed a little bit. So OSHA had posted an FAQ to describe when an employer needs to contact OSHA. So we can see in the top here, an incident is thus when an employee is exposed to the virus at work, as opposed to when the employee develops symptoms or tests positive. So that's really important to recognize. Now the next piece is inpatient hospitalization. Now in order for this case to be reported to OSHA, an inpatient hospitalization must occur within 24 hours of an exposure to COVID-19 at work. And so inpatient hospitalization, if an employee goes to the emergency room and they're discharged later that day, that's not inpatient hospitalization. If they're admitted to the hospital from the emergency room, that is inpatient hospitalization. And if we know it's work-related, in the COVID case, it's work-related and they're hospitalized, then you have 24 hours to contact OSHA. Now, if we look down here below, fatalities. Now, in order to be reportable, a fatality due to COVID-19 must occur within 30 days of the exposure to COVID-19. And in that case, the employer must report that fatality within 8 hours of knowing. So if it's work-related, they're admitted to the hospital, report it to OSHA. If there's a fatality within 30 days of being in exposure, you have to report it to OSHA within 8 hours of you having knowledge of that. So it doesn't have to be just 8 hours from the death. It has to be 8 hours from the knowledge of it. So two really important factors. If you have any more questions on this, I want to skip over so we can get this to Abe. But before we do, let's go a little off script. So let's do this. Everybody open up your chat box. We're going to do a little raffle here. We're going to do a $25 Amazon gift card to the attendee who can answer this question the fastest. So the question is, what is the penalty amount for not reporting a serious injury to Cal-OSHA within 8 hours? Not COVID related, just a general serious injury. Chat box is open, $25 gift card.
All right, guesses are pouring in here.
Here we go. All right.
Okay.
Sinead, what do we got?
I see it as is it Dilsha? I think I'm spelling or saying her name wrong. It's 5K, correct?
Correct, $5,000.
Yep, she's the
So
winner.
Congratulations. Well, Sinead will be sending you a $25 gift card, Amazon gift card. So just a reminder, if you have a general serious injury or illness, and if you go to Cal's site, you'll see the prior webinars. We had some safety tips regarding that. If you have a serious injury or illness, you need to report that to Cal-OSHA within 8 hours. And again, remember the inpatient hospitalization, a component of that. So congratulations, Dilsha. We'll send you a $25 Amazon gift card. All right, Sinead, let's move on. And Abe, you're up.
Great, thanks, Anthony. So let's take a little poll before we get started here. Are you familiar with the new reporting and notice requirements as required by 1159 and 685?
This poll should work now. There's just one.
There's only two options.
To choose from.
Set this one up properly.
Yeah. Well, I mean, there's a lot of information to go over today, and I know some of it may be a little bit overwhelming. So I just want to let you know before we get started, this is confusing even to attorneys that are reviewing it, and it's a brand new law. So it's going to take a little bit of time to get used to the new processes and protocols because it's unprecedented, especially as it relates to COVID-19. So there's, as far as the law is concerned, there's a lot of elements, a lot of time frames. It's not necessary that you memorize all of the things that we go over today. This is just to make you informed, and we're going to try and keep it really simple as far as what the employer obligations are. Now, there's not one size fits all rule for these new laws. I mean, there's going to be gray areas. Some of you may qualify, or your employees qualify for the FFCRA. Some of you might have an exception. So we're just going to go over it in the most broad terms possible, and we'll cover as much as we can. And obviously, if you ever have any questions, Cal is an awesome resource. We're also available as well as your insurance carrier, and I'll talk about that in a minute. Let's take a look at the results. Okay, about half and half. Yeah, and it's been in effect now for a little bit, a few weeks. So it's good that some of you are proactive. I can say that even if you have a little bit of familiarity with it, this will probably clarify some of the gray areas with regard to that. So let's take a look at the overall picture in California. Many of you may recall the last time we did this. We did have a snapshot back on August 10th. There was about 31,000 claims and 141 deaths. So not much time elapsed, and it's still on the uptick. And part of that, is going to be these new laws creating a presumption for outbreaks. A big or a large portion of these claims being filed, 41,861, are healthcare workers, frontline workers, public safety and government workers, some retail and manufacturing. As you can imagine, as we move forward and continue to open up and ease some of the restrictions, we're going to see probably the numbers uptick in some of the composition of the different types of industries also be affected. Deaths at 224, as I mentioned. And if you take a look at the total claims filed between the beginning of the year and now, it was just shy of 400,000. So COVID claims account for 11.2% of all the claims filed. So quite a few claims just COVID related. And I can say for a lot of my clients, some of them weren't reporting during that gap period where the executive order expired, and now we have this new legislation. Let's take a look at the high level overview of the two bills that we're going to be talking about today. So Senate Bill 1159, the rebuttable presumption is back, or it's sometimes alluded to as the disputable presumption. So what does this mean? A little bit of history. Many of you recall the executive order that was implemented by Governor Newsom when the initial shelter in place was put into effect back in March. He had a presumption that positive tests were, if they're working on site and met certain criteria, those were presumed to be work related, and you had to prove otherwise. So that's effective as of March 19th all the way till July 6th. And then we had this gap period where there really wasn't any special protection for COVID-19 positive tests that came in, even if they were working on site. Well, now this 1159 re-implements that with some important caveats. And I think that they're relatively good for employers as far as the changes that they made. There's now an outbreak requirement. So it's not just one person that comes in. Now it's a minimum of 4 positive tests that come back within a 2-week period before they apply this law or they apply the presumption that it's work-related, which makes sense because if you have a cluster of employees that are all working on the same site and they're testing positive within a couple weeks of each other, which is the latency period for this type of virus, then that makes sense. That's evidence at least that it is potentially work-related, and they're putting the presumption and the burden on the employer at that point. Obviously, penalties for both.
Just to hammer it home here, there was a good question about, with this change, are employers supposed to advise all employees now of when there is, somebody that tests positive, or is it just the potentially exposed employees?
Well, the language basically just says employees. Now, I think if you use your common sense and you have somebody that's totally off-site, that wouldn't make sense to actually provide them notice. And I assume that they're talking about 685 because there's no notice requirement for 1159. And we still have time under 685 to get more interpretation on it. It's not in effect till January 1st. But I will say you want to err on the side of caution. There's no real reason not to provide your employees with this particular type of notice that they're requiring. There's certain elements to it, and I'll go into more detail about what those elements are, what the actual law entails, because saying potential exposure is also kind of it's a gray area, and it's really hard to define because how do you know when somebody actually is exposed or where they were exposed? And that's part of the reason that we have this framework in the first place. Because how do you say whether or not something's work-related? How would you say a flu is work-related, for example? It's almost impossible to say, well, I definitively contracted this at work. So let's take a look at some more detail with regard to the first section of 1159. So really there's 2 main sections, and we're not going to cover the ones for police officers, firefighters, healthcare workers, frontline workers. The presumption obviously applies to them as well, but we're going to look at the broad category where all other employees fall, basically employees that are not working from home. So let's take a look at that section, and this is where the presumption applies a little bit differently. As I mentioned, there's an outbreak requirement. This applies to employers with 5 or more employees. Now, what is an outbreak for the purposes of this bill? If you have 100 or fewer employees at a specific site, you need to have at least 4 positive COVID tests within 2 weeks, and that's considered an outbreak. If you have more than 100 at one specific site, then they use the 4% rule. So 4% of your employees are able, so to speak, to have a positive test. Right before that, that's the threshold. And if you exceed that threshold, then those cases are presumed work-related at that point. And that's not the end-all be-all. You can still rebut that presumption. You may have had an employee come in and say, well, I actually got this at a family gathering. I'm pretty sure about that. You can use that evidence, and the carrier can use that evidence to rebut that presumption. But that's not something that you necessarily need to do. That's information that you just want to relay to the carrier so they can make a compensability determination. And keep in mind, there's a shortened window for investigation of these types of claims or these types of cases. So the initial burden after they have a positive test really shifts from the employee over to the employer. So what are some of the evidence that you can use to rebut it? I mean, some of the examples that they listed were, measures in place to reduce the potential transmission. So things that Anthony were talking about, your safety protocols, your IIPP, your training, your documentation thereof, those are all going to be really important. So once an employer knows or reasonably should have known that an employee tests positive, you have 3 days to alert the claims administrator. So what does that mean? There's really 2 paths for these types of positive tests. If somebody's not saying that it's work-related, you just have to document that with the insurance carrier. And the insurance carriers have come up with, and Joe, you've seen this, different forms in order to keep track of these and notify them, because you're not filing a claim for every single positive test unless somebody comes in and says, I got this at work. I believe this is, I contracted this from Bob in Division 1, whatever it is, right? So if you get that type of notice, you have to file the claim just like any other claim, just like any other claim where an employee alleges an industrial injury or illness, you're filing the claim. But the big difference with this bill is that you are giving them notice of also positive tests. And when you do that and they're not alleging that it's work-related, you're keeping their information confidential. You can use their employee ID. You're just giving the carrier the data. And the reason that you're doing that is so that they can keep track of whether or not you've met that outbreak threshold, so that the law applies. And if it does, what happens is they're presuming those cases are work-related once you cross that threshold. It doesn't mean that when you're reporting these or you're submitting this information that they're automatically work-related. Okay, so let's jump ahead. One other thing I want to note about that and the reporting requirement is that the claims that were after that July 6th period when the executive order stopped, the law is actually retroactive. So you still need to alert the claims administrator of any prior COVID claims. And many of you have been already reporting them, so they're already aware. But just to keep track of that. And the reason, again, is to do a look back to see if there were any outbreaks. And really in practice, you're gonna know if you have an outbreak. I mean, it would be you'd have to be pretty disconnected or a really large company not to know that you had an outbreak at a specific location. 4 within 2 weeks is pretty clear. So I talked about the reporting a little bit, but I think it's good to really hammer home what you need to do. So a little bit of homework that I've been giving to my clients is that pretend that you have a positive test, you know what to do. That's a really good test of whether or not you're comfortable with this type of law. And the first step in that really is to reach out to the carrier to get their reporting form for COVID. And a lot of them are really great. I'll show an example at the end of one of those, but really they give you a step-by-step guide of what to do when you get a positive test, how to submit it to them. If it's a claim, you're filing it as normal, but they might have a different protocol for COVID-19. Another good thing is to just have all this in one place. Take a look at your local health department guidelines. And obviously we can't cover all the different carriers' notices and whatnot, but that's something that you'll want to do as homework. So I'll have that for homework, and there's one for 685 as well. As far as the 45-day window, what they're doing with that is they're taking a look, and the carrier will actually usually ask you on the form, what's the highest number of employees working at a specific place of employment over the 45-day window. And again, the reason is to apply the outbreak threshold. Do you have under 100 employees or do you have over? So are we doing 4 or 4%? And then they give an example there as well. So let's take a look at a high level of this. I think it's, for me at least, I'm a visual learner. So I think if you flip to the next slide here, you can take a look. I think this is a really great representation of what you need to do at each stage. And once you see it in this way, I think it makes it a little bit more intuitive. As far as the reporting workflow, okay, employee tested positive. I mean, I won't read through each one of these. Obviously, you can see it, but if it's a no, then you're not required to report. And if you go all the way over to the third one on the top, you're completing the actual reporting form. If they've actually tested positive, they've been working. They're not working at home. So that should trigger in your mind to keep it really simple. Positive test equals action, right? What that action is going to be reporting. to the carrier first, unless there's some kind of serious issue, obviously, that you need to report to OSHA. But reporting, so is it work-related or not? If it's not, you're notifying the carrier with whatever protocols they have, whatever form they use for that, and you're keeping track of that, and you're looping them in. If it is alleged to be work-related, then you're giving them a DWC-1. You're filing the claim as normal. They're alleging a work-related injury. You have to file the claim. You have to give them the DWC-1. And again, I'll repeat this, for the ones that aren't claiming it to be work-related, you want to protect their identity. So just make sure that you're not submitting all of their information, maybe just something like an employee ID, the date that they tested, the location, and the amount of employees that are working on that site. That's all the carrier really needs to determine if there's an outbreak. And just to hammer this home, I'll go ahead and go over a case study at the end here that will have all these examples looped into one. So I think it'll make it a lot more clear too. So if you take a look at if you make it to all the way to the end of the reporting workflow, you can flip to the next one. You're going to get to the report the claim. I mean, this is just as normal, tested positive. Again, it's not somebody that's working at home, they're working on site. It's within a 14-day window that they test positive from the last time that they worked. You provide them the claim form. You don't necessarily have to fill out a 50/20 if your carrier has an online portal. They usually generate one for you, but you're just reporting it to the carrier. And if the claim is accepted, you're logging it onto the OSHA 300. And I'll go over an example in the case study where somebody was hospitalized. Inpatient hospitalization requires you to report to OSHA, not just record it on your 300 log, right? And Anthony went over that as well. So this is just a snapshot and an overview of what we just went over. Again, it applies to employers with 5 or more employees. The outbreak requirements are there. The testing positive within 14 days of working at an employer's direction. That basically means that they're just not going into an empty office and you had no idea. I mean, pretty rare, I would imagine. And then sorry, can you go back? And then basically with regard to the timeframes, you'll notice with both of these laws, there's really quick turnaround. So I think that's why preparation is best, right? Reach out to the carrier, have all this information so that should somebody need to call OSHA or the local health department or the workers' comp carrier, you just have all the data ready. You have the phone numbers, you're ready to go. Because you need to do this within 3 days. And you know how, a lot of things can blow up and things can get busy, especially around these times. So if you want to be proactive about it, I would reach out to the carrier and just get that form and then just take a look at the local health department, any requirements, grab their phone number, and then you're ready, at least on the 1159 side. And we'll talk about 685. Again, retroactively report your claims. You have 30 days to get all that information in. Let's jump over to 685. And again, I'll go over a case study just to give you a real world example of what that might look like and what an outbreak might look like. So this notice requirement. So again, really the homework on this one would really just be to create the notice. There's some pretty broad requirements as it relates to this notice. So it really is just saying that you have to provide notice to employees with potential exposure to COVID-19. So what does that mean? They may have come in contact with a qualifying individual, effectively somebody with COVID, somebody that tested positive or was diagnosed with COVID. And we'll talk about what a qualifying individual is. But the big kicker, I think, here is within 1 business day. They really want a quick turnaround. So if you're trying to create this big packet and notice for all your employees in 1 day and send it out, that's going to be extremely stressful. So I think that's one of the reasons that they didn't implement this right away. So what does this notice look like? I mean, they say written notice such as an email, text message, personal service, etc. That might be fine to do so that you can send it out within 1 business day. but you know, the amount of things that you would have to put into a text message will look ridiculous. Like, obviously you're not going to be texting out 3 pages worth of benefit rights and notices and anti-retaliation, etc. So I would recommend just having. Yeah, Joe, did you have a question?
Yeah, no, this actually brings up one of the questions that was asked, which is, you know, in a small company, how do you notify of potential exposure without violating HIPAA for the infected employee?
Yeah, no, that's a good question. You definitely want to keep the employee that was infected there, the information confidential, and that's not a foolproof method. Obviously, if someone's off work for a couple of weeks and you get this notice in the mail, you can probably put 2 and 2 together, but you can't divulge who that person is, why they're off. But you are just giving a general notice to employees that they may have been infected. And the notice itself, and I'll go into a little bit more detail, but the notice itself is going to include things like anti-discrimination and retaliation for reporting COVID cases. Some of this might be already in your HR handbook in some form, so I'd recommend you take a look at that and just use the COVID credentials as well to actually, you know, increase or enhance your current methods. But just maybe copying and pasting even some portions of that just really overlap, like the sick leave. You may already have your COVID sick leave, FFCRA if you're a qualifying business. All that stuff should be included, as well as their right to report a workers' compensation claim. Same thing that you give out in your time of hire packet. Just be putting something together, and we actually have a template in a few slides here just to get you started on that front. And one other thing too, with regard to the notice, they also want you to notify employees about the disinfecting protocols and safety plans to prevent further exposure per CDC guidelines. So that's really important as well. And with regard to the health department, this is one of the slightly more confusing things, because the definition of an outbreak for these different agencies, they change. Right now, the local health departments have a definition of 3 or more lab confirmed cases within a 2-week period. Well, you remember in 1159, they created this framework where it's 4. So they actually give you a little bit more leeway in that case. But for AB 685, if you have an outbreak, if you have 3 or more lab confirmed cases within a 2-week period, with some exceptions, but by and large, that should trigger action on your end if you start getting more than 1 claim, right? If you start getting 3 or 4, those outbreak triggers might kick in. And as Anthony alluded to, the power of Cal-OSHA has been expanded under this particular law, and I'll talk about that as well. So we talked about, can you switch it? We talked about the potential, or the notice of potential exposure. To the next one, Sinead. So we talked about a notice of potential exposure. So what does that mean? So the qualifying individuals that may have exposed other employees are people that come back with a lab confirmed case. That makes sense, right? You get notice of a potential exposure by finding out somebody either is diagnosed or has COVID, or you get an isolation order from a health officer, or somebody dies from COVID-19. So if you have these types of notices, that should trigger in your mind, I need to send out the notice requirement under 685. And that should already be prepared. And we'll take a look at what that looks like in 2 slides. So with regard to Cal-OSHA and just some of the notice requirement in general, 1159 is really the reporting requirement and 685 is the notice requirement. So with this expanded authority, Cal-OSHA can shut down an entire worksite if they think that there's an imminent hazard to employees. They can also, as Anthony alluded to, they can also issue citations. They don't have to have that 15-day delay period. They can issue it immediately. Some of these violations can start at $18,000. It is still rebuttable. It's not something that is automatic, but it is immediate. So another big change with 685, notification to employees, benefits related to their protection, their pay, their sick leave, as it relates to COVID-19. You'll have all that in one packet. And obviously the local health department, if you do end up having an outbreak, err on the side of caution with what your interpretation of that is. But right now it's 3 or more lab confirmed cases within a 2-week period at a specific location. And you have 48 hours to report to them. Let's take a look real quick at the sample. This is a sample notice. This is just to get you started. Do not just put your name on this and send it off to your employees. It will not be sufficient, but you want to make sure that all your own policies are in there. Perhaps have a labor attorney take a look at it. We'll probably have some more resources once attorneys start creating these for their clients as well, with some ideas how to touch on all these topics. But this is just an editable PDF that will be available on Insight. And actually, Sinead will be sending out a version as well. So there's a little bit of intersection between the two laws. So as far as the presumptions, it's really putting if you meet certain criteria, the burden is on the employer. And you can still rebut some of these presumptions, but the burden of proof is really just shift over to the employer in most cases. So there's obviously gray areas and a lot of what ifs for these types of applications, but again, it should be relatively simple on the employer side. Your obligations are just basically report and notice, and the triggers for that are positive COVID tests. So if you just keep it simple like that and just are prepared for when a positive COVID test comes in, you can utilize these resources, utilize Cal, utilize your carrier resources, then you'll be fine. The timeframes are obviously limited, more limited than a normal workers' compensation claim. They have limited time to investigate. The state really doesn't want a bunch of denials going out if there's a work-related injury, just generally. Enhanced reporting and notification requirements, as I discussed. 2 different outbreak definitions, again, that you don't necessarily need to know except for the health department reporting. You know, you're gonna know if you have an outbreak, and it may not be work related. An outbreak doesn't necessarily have to be work related, but you're getting notice of positive tests from people that are working on your site. So that should trigger action on your behalf. And I wouldn't worry necessarily about reporting these and thinking like it's going to affect your insurance. We've talked about this at the last webinar. The WCRB is removing these from the AXMOD as well. And some other employment law exposures. I won't go into these in detail because we went over them in our last webinar, but just know that those exposures are heightened under these new laws. So applicant attorneys are definitely looking to see if you're breaking any of these new laws or you're discriminating any of your employees against any of your employees. Let's run through a case study real quick. So in this particular case study, we have 4 employees working at a factory with 85 workers on site. So again, the threshold for 1159 is 4 because they have under 100 employees. A believes they contracted COVID at a family gathering, able to get tested. They tested positive within 14 days working on site. B rides to work with A in the same vehicle, but also works at the same facilities, all A through D, and also contracted COVID at work, alleged that it is work-related, and ends up in the hospital, inpatient. C works at home typically, but came in on site one day to collect a work packet and later tested positive. The work packet was required to do her work. She was directed to do so, just to make that clear. And D works on site, has COVID symptoms and asked to be quarantined, does not have a positive test. So those 4 cases are pretty unique, but also common in a lot of ways. So let's take a look at the 2 options for reporting, because for as far as the positive test, we have 3 here. So what are the options? You either 1, decide that they're not alleging that it is work-related, right? So if they're not alleging that it's work-related, you still need to send a notice to the carrier, in whatever form that they tell you is their protocol. They might have a PDF, they might have an Excel workbook. I've seen a lot of different ways to notify them, and you're keeping their information confidential. So that would be true for A and C. For B, allege that it's work-related, you're giving a DWC-1 if you see the person and you're filing it as a normal claim. But 3 tests, 3 notifications to the insurance carrier. Let's take a little more detail on the next one. So this just goes through what I just talked about with regard to withholding the identity, making sure that you're still alerting the carrier. With B, remember that that particular employee was hospitalized. So we need to, they were inpatient hospitalization. It met the definition that Anthony discussed previously. So we're notifying OSHA on that particular claim. For the second, or for the third claim, it's the same as A. You're reporting that positive test confidentially. And D, what we need to do for them, hopefully you can help them get the test, because they may be just on leave then, because this particular employer qualifies for the FFCRA. And remember, if they're quarantined under the FFCRA, they can collect that paid sick leave while they're pending that test. But you want to help that along so people aren't just off work for extended periods of time and maybe negative. So let's just skim through the next one. We talked about what the outbreak requirement is. And one other thing on this is, now that we have 3 positive tests, we have the OSHA reporting for the one claimant that was inpatient hospitalized. We have 3 positive tests. So that means that should trigger the local health department to be notified. And once 685 is implemented, you're going to have 48 hours to do so. So we've gone over each one of these elements already, but just so you know, you want to take a look at reporting to the carrier. Whether it's confidential or not will depend on whether or not they're alleging it's work related. Health department, is there an outbreak or 3 or more cases within 2 weeks? And OSHA, is it serious? Does it meet the definition of serious illness? Then you need to call them as well for that particular case. I think that sums it up well. We just included this slide for the FFCRA. Most employers qualify or fall under the FFCRA, and many of you are probably already familiar with it. I just wanted to put that note in there for D, because they're still pending a test, and I've gotten questions like, hey, they don't even have a positive test. Why are we letting them be at home on sick leave? So check and make sure that your particular company falls under the FFCRA. If you have 500 or fewer employees, it's very likely. There's some industry exceptions, but just wanted to include that in there as well. And we have a PDF about employees' rights. We're running short on time, so I just have one other slide here. So this is an example from Berkshire Hathaway that shows what they use for you to notify them of a positive test, whether that be industrial or not industrial. So again, the homework I would say is to reach out to the carrier and see which forms that they're using. So just so that you have it in case you get a positive test, you're not scrambling at the last minute to try and find it, because you do have to let them know within 3 days. Okay, with that, Sinead, sorry for the lack of time. I'll kick it back to you.
No worries. Thanks, Abe. That was super informative. Well, we also want to let you know we are here to help. We do, of course, partner with Cal, and we have quite a few clients that are already within our Insight portal. So within our Insight portal, we have all the resources that we shared through this presentation and more. Our COVID-19 compliance library, it tends to be obviously the most popular thing within our Insight portal right now. It goes through all of these different subjects here. So if you do need help with getting your documentation in order, creating maybe an exposure control plan, revamping your IIPP, getting social distancing protocols in place, those types of things, we have the framework for you all throughout our COVID library and more. So right now we are offering a COVID discount to our subscription for Insight. So it's a yearly subscription. Right now it's $760, which is a 47% discount. But if you already are a Cal Insurance client, we actually have an even deeper discount. So if you are interested in learning more, definitely reach out to us. There's going to be a survey that's going to come through right at the end when we close out on this presentation. So if you wanted just to hop on there, there's just 5 simple questions. It's super, super fast. We'll be able to reach out to you if you are interested in learning more and how to get insight. So I'm going to turn it over to Joe now to close out.
Well, I just want to thank everybody for their attendance today. I mean, we're all in this together. We have been really since March, and there have been a number of people, as I said, that have been with us on each one of these webinars. Now, this being the 7th in the series. And so, you know, it's overwhelming. There's a lot going on. It's tough for business owners right now, naturally, but we are in this together, and Cal and ESM are here to support our clients and to help you out. And to the extent you're not a Cal client just yet, we encourage you to give us a ring, reach out to us via email, via the web, and we will help you out. So thank you to ESM. Thank you to the participants today. We appreciate it, and take care and be well. Thanks, Sinead.